Hello, my name is Richard Garza with ERA King Real Estate. I will be discussing ʻkæviːɑːt Emptor, which is Latin for let the buyer beware. Generally, ʻkæviːɑːt Emptor is a property law doctrine that controls the sale of real property after the date of closing. Alabama is one of 3 states which still goes by this legal principle. Under the doctrine of ʻkæviːɑːt Emptor, the buyer could not recover from the seller for defects on the property that rendered the property unfit for ordinary purposes. Keep in mind that let the buyer beware does not apply to new construction. And also remember that this is not a substitute for legal advice. If you have any doubt at all, please consult a real estate attorney. I'll be using terms such as seller's agent and buyer's agent throughout this brief discussion. A seller's agent is the realtor who assists the seller of the property. Sometimes you might hear him referred to as a listing agent. The buyer's agent is the one assisting the buyer of the property. Your realtor is required to disclose their relationship at the first available opportunity. So just in case I forget, please ask them so that you will always be 100% sure. Under the principle of let the buyer beware, when a buyer who finds after a sale that the used house purchase has a material defect, neither the seller nor the seller's agents will be responsible unless the buyer can prove the following. There was a material defect which adversely affects health or safety. The seller or the seller's agent knew of the defect before the sale. The defect was such that it could not be discovered by due diligence, and the house was not bought as is. Buyer's agents. A buyer's agent who knows of material defects is in a very different position. Agents of the buyers have a responsibility under the law of agency to tell the buyer everything known about a transaction. ʻkæviːɑːt Emptor does not apply and offers no protection to agents of the buyer. The principles of ʻkæviːɑːt Emptor do not allow a seller or the seller's agent to engage in fraud or deceit or to make misrepresentations about the conditions of the property. If a buyer asks a question about a specific property condition, the answers must be truthful and complete. They can be liable for fraud if they knowingly take action to conceal a material fact with intent to deceive or mislead the buyer. Misrepresentations and fraudulent actions are very different from simply remaining silent about matters one has no duty to disclose. Should this prevent you from purchasing a home in Alabama? Absolutely not. There are measures that one can take to protect you and your purchase. Get your home inspected by a licensed inspector. I always tell my clients that one needs to get a home inspection. This way, there will not be any surprises. Don't take the selling agent or seller's word that everything is good. It is not that expensive to get a home professionally inspected, and it is money well spent. Review the purchase contracts. Ensure that there is proper verbiage that protects you and your interests. Read the contract before you sign. Ask questions. If you are in doubt, ask. This is too important a transaction to be rushed into signing what you do not totally understand. Deal with a reputable, knowledgeable realtor. This is the most important element. A good, honest, reputable realtor will be knowledgeable about ʻkæviː̈t Emptor and will ensure that your interests are being addressed. I hope that this discussion about ʻkæviː̈t Emptor has been helpful. If you have any questions about this or any other real estate issue, please don't hesitate to contact me. I may not be able to pronounce ʻkæviː̈t Emptor properly, but I do know how to ensure that your interests are being addressed. Thank you, and God bless.